One of the biggest misconceptions about the way plea deals are negotiated in federal court is that you can always get a better offer. This is completely different than state court. In state court, you can go back to court multiple times. You can talk to different DAs, you can bring in mitigating information, and you can try and get a better deal for your client. You can have charges changed, you can have charges dismissed. You can go into chambers and you can talk to the judge and you can get an offer. You go to preliminary hearing, you then go to the settlement judge and get an offer from them. So it's a moving target in state court. You can always have charges changed. For instance, you can have an assault with a deadly weapon. There's a bar fight, somebody gets hit over the head with a bar stool, and you can plead it down to a disturbing the peace potentially, depending on the circumstances of the case. That is not how it works in federal court. Prosecutors in federal court, assistant U.S. attorneys, Department of Justice attorneys are very black and white. They have rules that they have to follow, and the facts are the facts. The law that applies to the facts is the law that applies to the facts, and the sentencing guidelines chart is where they come up with the offer. So if you are charged with a $1 million fraud case and it's a conspiracy, you're going to have a base offense level of 7. The amount of loss in the case is going to determine the increase in levels. If you are a leader organizer, you get more points. If you had a position of trust, you get more points. All of these different factors play into it. Now, with the new amendment, if you are a 0-point offender, meaning you have no prior record, you can get 2 levels off. You get 3 levels off for pleading guilty. And there may be all sorts of other things. If there's an identity theft allegation that you have to plead guilty to, there's an extra 2 years. But this is the plea agreement from the government. There are all kinds of conditions in the plea agreement. You obviously can't violate any laws. You're waiving your rights to appeal the conviction and, in most cases, the sentence. That is where the work begins for your attorney in federal court. That is where the mitigation is argued to the judge. And judges in federal court do take everything into consideration. They look at the nature and circumstances of the offense. Why did you commit this offense? What were the circumstances surrounding it? Did you have a minor role? Did you have an aggravating role? What is the history and the characteristics of the defendant? And this is where we get into the entire explanation of anything horrible that's happened in your life, everything wonderful that you've ever done, your accomplishments, your failures, everything that you want the judge to know about you in order to get the judge to see you as a person. And this is where you have the opportunity to get your sentence reduced. Also, if you cooperate, there's also safety valve. These are videos that I've done before on all these different topics. But this conversation does not happen with the U.S. attorney. Now, it can. I will very often give the client's narrative or their life story with all of the mitigating information and their statement of remorse to the U.S. attorney prior to them giving me an offer so that they understand who my client is as a person. And maybe they'll leave off 1 count of identity theft, or maybe they won't charge the money laundering, but that is very, very rare. The U.S. Attorney's Office and the U.S. attorneys that work there are under strict orders by the Department of Justice and the Attorney General of the United States to file the charges that are available for the conduct. So when I have my clients in federal custody talking to other inmates who are in custody and they say, well, so-and-so got a better deal or so-and-so got something better, they may have negotiated certain language where you didn't like the facts that were listed in the document and you say, well, that didn't really happen, so you got that changed. Maybe you convince the U.S. attorney to give your client a minor role adjustment because they really weren't that involved, or even a minimal role adjustment where they get more time off. There are little things that we can work with the U.S. attorney on, but they're not going to move the needle drastically. We may or may not be able to get safety valve depending on the charges. The U.S. attorney may say, yeah, but there was a gun. I can't give him safety valve. My office won't let me. And that's the other thing. The offer is presented to the supervisor at the U.S. Attorney's Office by the assistant U.S. attorney, but it still has to be approved by their supervisor, and sometimes it goes all the way up the food chain to the head of the division, either in that district or even sometimes it goes to D.C. Tax crimes have to be approved, or tax offers have to be approved by the tax division of the Department of Justice. So that's something that a U.S. attorney can say, look, I'm going to ask for this, but I don't know if I can get it. I can't make any promises. So we hear that a lot as attorneys. I can't make any promises. I'm going to try to get your client this. This is what I'm thinking, but this is not an official offer. And until it's in writing, it isn't official. So once you get that plea agreement from your attorney and she sits down and she goes over it with you and says, this is what we're looking at, it is very unlikely, it is highly unlikely that anything better is going to happen when it comes to your offer from the U.S. Attorney's Office. You may get something better from the judge when you have an outstanding attorney arguing all of the mitigating factors in your case, and that happens a lot when I'm arguing sentencing in front of federal judges. But as far as the offer, when I hear my clients say, I want a better offer, it's very unlikely that that's going to happen in federal court. State court, yes, absolutely. Federal court, sorry.